Hi, my name's Christine. I'd like to share with others my experience with Mr. Davis. I have a juvenile dependency case, and Mr. Davis has gone above and beyond and has been so amazing with me and my family. He has not only been an incredible attorney, but an amazing person and friend. He
Good morning. This is Attorney Vince Davis, and these are my office hours. Today, we're going to cover it all. Every major issue that families are facing with CPS have asked us about. These are the questions people are too afraid or too overwhelmed to ask, and we're breaking them down. So let's get into it. Segment 1, CPS Basics and First Contact. Question 1. What triggers a CPS investigation in most states? Well, in California, things that are triggered by CPS investigations are usually referrals made by mandated reporters. It's very rare for a CPS social worker to witness child abuse or suspected child abuse themselves, just living or seeing things in the public. So you're usually referred by, a doctor, a school teacher, a school nurse, a therapist, or a counselor. And that's usually how things are triggered and referred to CPS for investigation. The next question, if a social worker knocks at your door, do you have to let them in? The answer is no. You do not have to let a social worker in unless they show you a warrant that they have to come into your house. Now, in California, they can only get a warrant for a certain type of thing or types of things. Number one, they can get a warrant to come and get your children, to detain your children. Or they can get a warrant to come and investigate your house. They can get a warrant to come and talk to your children, okay? But they can never get a warrant to talk to you, all right? So it's there used to be in the code in California, and I don't know if it's still there, there used to be a section where it's explicitly stated that you didn't have to talk, that the worker had to give you some type of warning. It was a type of Miranda warning, where you didn't have to talk to them without an attorney being present. And I don't know if that's still in the code, but it's my advice to most people in most situations that don't talk to a social worker without an attorney being present. So if the social worker shows up and doesn't show you a warrant, then you don't have to talk to them. You don't have to let them in, even if they're accompanied by the police. I have been on I've seen some occasions where a social worker will show up, ask to speak to your children, and when you say no, then they pull out a warrant and they show you, and you can read it, and it says that a judge has seen or has given them the authority to speak to your children. But remember, if they do have that warrant to speak to your children, that doesn't mean that you should get into a conversation with them, because everything that you say, it will be used against you. And I've had many people tell me that they have been misquoted by social workers from not only being misquoted, but have been social workers have attributed things to them that they never stated. So be very, very careful. Next question. Can CPS take your kids without a court order? Well, they often do, from what I understand, but they're not supposed to. And if they do, it's a violation of the Fourth Amendment. The only exception is if there's an exigent circumstance, meaning an emergency. Can they take your children? If they take your children without a court order or a warrant, you should talk to an attorney, a civil rights attorney, because there is a good possibility that your civil rights have been violated. All right. What happens during the first CPS interview? Well, the social worker is going to be asking you questions about, um, the alleged abuse, about what you've done, what you haven't done. That is why you probably want to have a lawyer with you so that you can make sure that you don't say anything that's going to be incriminating or used against you in the future. Okay, question 5. Why do so many parents make mistakes during that first visit? Well, they make the mistakes because they're not informed, and they make mistakes because they think that they can out talk, outthink, and out strategize and outmaneuver the social worker, which in most cases isn't true. Social workers, whatever you think about them, are highly trained individuals. They're trained at their job and they're trained to get information from you. So please be careful. Please understand that social workers know what they're doing and they are in this situation because they are paid, they're professionals, and they're trained to get information and build a case against you. Oh, I see that we have Miss G joining us. Let me bring her on the studio. Good morning, Miss G. How are you?
Good morning. How are you doing?
Good. I'm started the show already, but I'm on segment 2, the legal rights and representations. You want to take over the questioning?
Sure.
Go ahead.
Let me go to segment 2. Okay, so you're already done with segment 2?
No, I'm starting segment 2.
Oh, cool. Okay, what are the parents' rights during a CPS case? What do they have? Do they have any rights at all?
Yeah, they have the right to representation. At least in California, they have the right to have an attorney. If they can't afford one, one will be appointed to them. I thought that that was a right in every state, but I spoke to someone not too long ago. I
Mhm.
forgot what state it was, but I was surprised to find out that in that state, they don't appoint you an attorney if you can't afford one.
Are you,
But in California, you have a right to an attorney, and if you can't afford one, they will appoint you an attorney, and you have the right to remain silent. You have the right against self-incrimination. Now, unfortunately, at a certain point in time, if you remain silent after, for example, the jurisdictional hearing or the dispositional hearing, it might infringe on your ability to reunite with your children. So whether you stay silent or not is something that you should discuss with your attorney.
okay.
Next
Um,
question.
what's the difference between a court-appointed lawyer and a private attorney?
Well, a court-appointed lawyer is one that usually works for the county and the court and is appointed to you when you can't afford to hire a private attorney.
Mm-hmm.
Um, it's the same in criminal cases. When you can't afford a lawyer, the county and the court will provide you with a free lawyer.
Mm-hmm.
Court-appointed attorneys usually work for a law firm that just does court-appointed work. In some counties, court-appointed attorneys are private attorneys that do court-appointed work. In Los Angeles, there are, I think, three or four different law firms that do exclusively court-appointed work, and they're appointed to represent parents. And then there's a court-appointed law firm that is appointed to represent children, and that's their quote-unquote specialty. But they all work for the county. They all work for the state. Private attorneys are just private. Meaning they work for themselves, and clients find them and discuss their case with them and hire them. They tend to be more independent, and sometimes clients want attorneys that are, not connected with the social workers or not connected with the
Mm-hmm.
county.
Right.
I've had people hire me because of my geographic location. Sometimes people will tell me, I didn't want an attorney that was, from my county, because
Right.
I felt that they were all in coercion. I don't know if that's true or not, but sometimes people don't even want an attorney that's from that county.
I can understand why. Can a parent, how can a parent get the most out of their court appointed lawyer?
Well, it's like anything else in life. You get more bees with honey. Uh, the most, the best way is to try to work with that person, try to cooperate with that person, and to help that person at every turn. Provide them with information, provide them with the documents and exhibits you think that they will need. You know, you should probably email them, have a record of everything that you send them so that they can, review it, write summaries for them, write things, review the reports, tell them what's true, what's not true, give them witnesses, give them exhibits that they can possibly use in their case, help them work the case up, ask for them to periodically or suggest with them to periodically meet with you. Making demands on anyone is probably not a good idea. Um,
It's not about demand.
you
They
asked
don't
me the
treat
question,
parents
right?
like that. They don't treat parents with dignity, what I'm
You
saying.
asked you asked me the question, right? So let me answer it. Um, the question is, how to get the most out of your attorney? All right. So I'm telling you what I think after almost 40 years of doing this, how to get the most out of your attorney. Now, it may be a negative situation, but this is how you get the most. You get more bees with honey. And if you feel that you are not getting what you think you should be getting, or there's a conflict between you and your attorney, there's something in California and probably in every state, there's something called a Marsden motion. They probably call it different things in different states. But that Marsden motion is to make a motion to get a new court-appointed attorney. But you have to have certain facts and certain information. You just can't go and say, "Hey, judge, I'm not getting along with this attorney. Um, I need a new attorney." The judge will probably deny you. Okay, I think on my YouTube channel, I know on my YouTube channel, I've done a video or two on how to be successful in getting a new attorney through a Marsden motion. So take a look at that.
Can the parent just fire the attorney if they're unhappy instead of doing the motion?
Yeah, the parent can fire the attorney anytime. However, that may leave the parent without a lawyer or may lead the parent to hiring their own attorney, spending their own money. And I've seen it in a lot of cases over the years, if the parent fires the attorney, the judge may allow you to be your own attorney with the assistance of a court appointed attorney, and it may be even the attorney that you tried to fire. Because in California, they don't want you to be, they don't want you to represent yourself. Although a lot of people have the opinion that you have the right to represent yourself, and that's not necessarily true. It's always been my opinion, and I know every case is different. It's always been my opinion. It's better to have an attorney than no attorney, even if it's an attorney you don't get along with.
Okay, we're going on segment 3 now. Hearing and timelines. What happens at a detention hearing?
At a detention hearing, the court will read, or your attorney will give you the information, the allegations that are being pled against you by the social worker. And the court will inform you of certain rights that you have. And the most important thing, if your children have been detained, there will be what's called a detention hearing, where you will have the right to make argument and present evidence and try to convince the judge to return the children to you.
And do you consider that the most important hearing, though, to hire an attorney like right away?
Well, if you're going to hire a private attorney, you probably should do it right away. But one of the mistakes people make
Mhm.
is they think, well, let me wait and see what happens at the detention hearing and then hire the attorney. There are a
Right.
lot of key things that happen at a detention hearing. Um, Let me give you an example. One of the things that you might want to do is you might want to change judges. Well, you want to do that at the first hearing, not after the not after the first hearing. The judge
Whoa.
has already ruled against you. And um, I won't say I've never seen it, but it's probably unlikely that your court appointed attorney will file an affidavit to get rid of that judge,
Right.
right? That court appointed attorney always works in that courtroom, usually. So that's one thing, whether you set the case for a no time waiver trial or just a regular pretrial happens
Mhm.
at the detention hearing.
So
And
this is so
pardon
it's
me.
important to change the attorney on the first hearing if people don't like. I mean, the judge, if people don't like the judge from the beginning.
Right. Don't you
Mhm.
think? I mean, if you think the judge is going to be unfair, why let the judge hear the first hearing? You just want to confirm that the judge was going to rule against you at the first hearing, and your kids are going to stay in foster care for the next, 4 to 6 weeks.
Right. No, the reason I'm shocked is because a lot of parents ask me that question, and usually they ask me that question during the end, like at the end of their hearings already, like they're going to termination of parental rights.
One of the things that I see a lot is people will call me, and I'll talk to them before the first hearing, before the detention hearing, and then they think that they'll go to the detention hearing.
Hmm.
They'll use the free attorney, and they'll see what happens, right? And then they'll call me back and they'll say, hey, things didn't go well. I want to hire you. And by the way, can you fix what happened at the detention hearing? And the answer is generally, no, I can't fix it, right? It already happened. Well, the attorney didn't do this, and the attorney didn't do that,
Hmm.
and I want to change. I want that redone. Well, you can't redo it. If you wanted to do all that, like we discussed
Right.
before the hearing, you probably should have considered hiring me. Well, I wanted to see what would happen. Okay, you saw what would happen. It wasn't good. Now I have to come into the case and I have to fix all that. Someone
Okay.
once described it like this. Now there's been a car accident. Okay, the two cars have collided, they're stuck together. Now you want me to come and pull the cars apart, fix the metal, and have the cars drive off on their way. It would have been easier for you to just hire me before the accident, but you wanted to see what would happen. Now you say,
I know you use an accident as an example, but I think it's worse than an accident, to be honest with you.
it is because, we're talking about your children.
Yeah, it's a lot worse than that. People don't get it. I wish I was with you yesterday when you did the relatives show. Um, there's so much to say about that show. Do you think we can do one tomorrow or Monday morning?
Doing what? A show on relatives? Yeah, we can. You can do a question and answer session on the relatives.
Hmm. I would
You
like to do that with you. Yeah.
okay? All right.
So you can let me know if you want to do it tomorrow or Monday because I there's a couple of actually there's about 8 parents that having problems with their relatives right now because their relatives believe CPS. So I think they need to hear that from you. Okay.
All right.
All right. Um, moving forward. Um, what is the purpose of the 6 month review hearing?
The 6-month review hearing is a statutory hearing, meaning it's a hearing that's held by law to review the case every 6 months after the disposition hearing. So it's to review the case to determine your progress in the family reunification services or with family maintenance services. And the court reviews your progress to determine if the child has been, if you should have the child returned to you, or if the child stayed with you, if the case should be closed. That is the purpose of the 6-month review. And by the way, you have the right to challenge the 6-month review recommendations by the social worker, and you can challenge it by way of trial.
I hope you can say that again one more time, please. You have
You
the
have
right to what? Because
you
I
have
want people to hear that.
you have the right to challenge the social worker's recommendations at the 6-month review hearing, and that's by way of trial. But here's the tricky part. A lot of judges have this rule. You get the report for the 6-month review hearing at least 10 days before the hearing. And when you show up for the 6-month review hearing, you must be ready to do the trial that day. And if you're not ready, too bad, so sad.
Oh my God, wait a minute. So the 6-month review hearing, they have to be ready to do the trial that day. So if their court appointed attorney discourages them from, they're going to lose if they do the trial that day,
Because they're not ready.
they're not ready. Did you guys hear that?
So now there are a lot of judges that do just the opposite. You get the report 10 days before, you show up at the hearing, and if you're not in agreement, the judge will set a hearing in the future. But you got to find out from your attorney, you got to call the clerk and say, hey, which rule does your judge do? So, it might be 50-50. I'm doing a case coming up in a couple of weeks, I think, or a 6-month review hearing where I ask at the disposition hearing, I said, hey, judge, if we contest the 6-month review hearing, when is the contest or the trial going to be? Are we going to pick the trial date on the 6-month review hearing date, or do we have to come prepared for the trial? And she said, you have to come prepared for the trial. And as a matter of fact, Mr. Davis, I'll order the social worker to give you the report 14 days in advance. And we got the report 14 days in advance, and we're preparing for the trial on the 6-month review date, which is in, I think 10 or 11 days from now. But we have to show up and be ready for the trial. Now, nobody has asked us if we're going to trial or not. Just out of courtesy, I'm going to, in about 3 or 4 days, I'm going to send out a witness list, an exhibit list, so that they know that we're going to be going to trial, and they know that we're going to be having witnesses and exhibits. But they wouldn't even know if I didn't even tell them. And that wouldn't preclude me from having a trial, but that's just one of my best practices to let them know, so that on that date, they can't say, oh, I need a continuance because Davis didn't tell us. And Davis has all his witnesses there, and it'll be a waste of time.
Got it. This is actually a very important question also. What does it mean if reunification services are terminated? A lot of people think they still, that they can lose hope, basically, just hope gone.
Well, it's a bad thing. If you're a parent and you have that hearing, usually at the 12 or 18-month date, sometimes at the 6-month date, sometimes at the disposition hearing, where your reunification services are terminated. That means that, number one, the court is no longer working towards bringing you and the child back together. The court is now focusing on a permanent plan to keep the child out of your custody forever. So it is a bad thing. Now, can you make a comeback from that? Yes, you can. And there are many ways to do it, but it won't be with the social worker helping you. So if your family reunification services have been terminated, you better talk to your attorney ASAP on a plan and a strategy to get you back in the ball game, because you're heading towards losing your child permanently.
Yep. Um, I tell them this. I say the following: always communicate with your court-appointed attorneys via text or email,
That's a
because
good idea.
often, yeah, yeah, oftentimes they'll say they didn't know. Um, so we're going on segment 4 now. Motions and evidence. That's important. What is a 388 petition, and when should a parent file one? That's a very good question too. I was just asked that yesterday. When should a parent file a 388 petition?
Well, it all depends. It depends on the case, the facts, and circumstances. A 388 can be used for many different things. And generally speaking, a 388 is a petition slash motion to file when you want to change a previous court order.
Mm-hmm.
A previous court order could be having your child placed in a foster home and you want the child moved to a relative's home. A previous order could be the court terminated your family reunification services and you want to ask the court to give you more family reunification services. So it could be used to change many things. A 388 can be used to set aside jurisdictional and dispositional court orders because you weren't given proper notice of the proceedings. So it can be used for many different things. And when should you file it? Well, it just depends. Talk to your lawyer. Give me a call to determine whether you should file a 388. Now, I must say that in California, it's called a 388. In other states, it's called something completely different, right?
Yeah, they just have to put it in Google search and they will tell them what it is in their state. I learned that from you actually. Um, can a parent file their own declaration and exhibits?
That differs from judge to judge, county to county, state to state.
And also the case, the length of the case, right?
No, it
Oh,
just depends on whether the judge will allow it.
okay.
Sometimes the courts give the attorney 100% latitude in what should be done in the case. Sometimes the judge allows the parent to file something. So it just depends.
How can it?
What I would do is I'd prepare it anyway and try to file it or give it to my attorney and ask the attorney to file it. And that, of course, would be done via email.
And another question: how can a parent challenge what's in the social workers CPS social workers report?
The best way to do it is by way of having a trial.
Mhm.
Although and I've been doing this a long time, but I'm starting to believe that one of the ways that should be considered on how to do it is to also, and I said this is also not in place of, but also of a trial, but also to file your own statement, your own declaration under penalty of perjury, and have the attorney use that in terms of strategy or roadmap at the time of trial.
Um, is there any way possible we have a brief time to address Dorothy and Erica's questions after this?
Certainly.
What kind of evidence carry the most weight in court? Because there's a lot of people have evidence, right? But I've seen evidence people have, like for example, like um, recordings, um, where you don't see the face of the person, but you can hear their voices, right? I don't know how good evidence that is, especially in CPS court, and they say that this is the social worker talking, the social worker can easily deny it, right? The social worker can say, that's not me. They hired
Mhm.
somebody to act like me. So they think this is good evidence. So can you explain that to us, please?
Well, in my opinion, the best evidence is a witness testimony. Second best is exhibits, documents. Including in the definition of documents are video recordings. And video recordings or audio recordings are like anything else. A foundation has to be laid to prove that it is the person that you're claiming it to be. Now, that could be your own testimony, or it could be the testimony of someone else, or it could be exemplars where the judge could hear and compare
Mm-hmm.
someone's likeness or voice. So there's a lot of ways to skin that cat, but you have to be careful, especially in California and maybe in other states. You can't record anybody without their permission, generally speaking, unless one of those exceptions are made. One of the exceptions is, I think, and I always have to review the law on this, a public setting or the commission of a crime, right?
Government officials can be recorded without notice.
I don't know if that's true or not.
Mm.
I mean, I'm not saying that you're wrong. I'm just saying I don't know.
Mm.
I don't know.
Yeah. They just don't like to be recorded. I actually, yeah, they don't like to be recorded, but that's because they lie.
You know,
So,
one of the things is that if you tell a social worker that, hey, you're being recorded, and they keep talking, then you're good. All they have to know is you're being recorded. They don't have to agree to it. All they do is have to know. And a lot of times, the notice is that sign on your front door or next to your front door that says these premises are video recorded.
24 hours, yeah. How can an expert witness help in the CPS case? An expert witness, like, Mr. Okari, for example.
They can help tremendously in CPS cases. Expert witnesses are probably, in a lot of cases, one of the most important types of witnesses because their opinions sometimes easily trump social workers' opinions because social workers are not experts in anything, generally speaking. But if you want to get an expert to come in and testify about, drug testing or drug counseling or, you know, your domestic violence counseling or your anger management counseling or just about any topic, medical, the cause of an injury, you might want to have a doctor come in to testify. You
Especially
would,
the drug expert, right?
yeah. But let me give you an example. I did a case in Sacramento with another attorney, and the social workers claimed that the parents caused an injury, a fracture to a baby. And we got an expert who came in and reviewed the x-rays and the medical records, who proved and gave the opinion that the child's bone was broken, but it was broken at a time period when the child was in intensive care at the hospital.
Mm-hmm.
And he went further to say that that injury probably occurred when the child was given CPR. Because in the medical records, the child apparently was passed or had passed away or something, and they had to give emergency CPR to the child.
Yep.
And the expert went on further to say that this is the type of injury that would happen if you gave CPR the incorrect way, which I didn't know. I didn't, you would think CPR is given the same way to all human beings. But apparently, when you're a little baby, you give CPR a much different way than you give CPR to an adult. So the injury the child had was an injury that it would sustain if you gave CPR the wrong way.
Right.
So he explained the injury. He explained the timing of the injury. He was
Mhm.
very adamant that the timing of the injury, from looking at the x-rays and the healing rate and all of that, took
Mhm.
place while the child was in the hospital. So the parents couldn't have done it. And, that was a case that we won. I wanted to later sue the hospital, but the parents didn't want to pursue it. But that was a classic case of medical kidnapping. You know that book, You Lose Your Kids Because of Medical Mistakes. They claim, child abuse when it was medical negligence.
Exactly. How can grandparents or relatives request custody of a child in foster care?
Well, the easiest way to do it, and what a lot of people think is the only way, and it's not, is to ask the social worker.
Yep.
And yesterday on my show, when I talked about this, I said, you should give the social worker about 1 week. If the social worker doesn't give you the child within 1 week, you should take on, making your request through the judge. And there's a way to do that. There's the steps that you have to take. To be honest with you, if the social worker wanted you to have the child, you'd have the child in a few days. So if the social worker continues to stall you, the odds are that you're not going to get the child. And I say the odds are. The social worker may change their mind in the future, but those are the odds. I have a case coming up where um, the social worker wanted to place the child, or wants to place the child, with a relative in Texas. And the relative in Texas wrote a letter and told the ICPC worker from Texas that he wants the child to stay where the child is. But the social worker is still trying to push the relative to take the child, and the relative saying, look, I don't want the child. I want the child to stay where the child is. So if you're a relative, give the social worker no more than a week, and then talk to an attorney about going to court to get the child placed with you. Remember, the social worker doesn't make the decision on where the child is placed.
Yep.
The judge makes the decision. The
Yep.
social worker will make the decision if you don't challenge it. You must challenge the social worker's decision if you don't like it.
What is the legal process for relative placement under the California law?
What is the legal process?
Mm-hmm.
Well, if you're a relative, the first thing you do, if you're going through the social worker, is you just let yourself be known that you want the child placed with you. The social worker can do what's called an emergency placement and just place the child with you. A lot of social workers tell relatives they have to go through something called the RFA process,
Mm-hmm.
uh, but that's not accurate.
Did you hear? Can you say it again? Did you guys hear that? RFA process. They tell you that the family have to go through RFA process, and Attorney Davis said it's not accurate, and he's explaining why.
As a relative,
Mm-hmm.
there can be something called an emergency placement pending your RFA approval.
Right.
Okay. So you can get the child today. They'll come out and look at your house. They'll run what's called a live scan. They'll
Right.
see if you're a criminal, but,
Right.
that's a 24-hour turnaround. So once they come out to your house and show that you're not a convicted criminal or child abuser, they can just place the child there. Then you can go and get your RFA process approved. Right. But a lot of people tell me, I can't get the child until I complete RFA. Well, that tells me right away that's called a red flag. That's called social worker doesn't want you to have the child,
Right.
because
So
that process takes weeks.
what does CPS really mean when they're saying we're evaluating a relative? They always tell the parents that we're evaluating the relatives.
What does that mean? To me, in my opinion, that means they're stalling. they really don't want to place the child with a relative, because the evaluation that they need to do to place a child with a relative can be done in 1 or 2 days.
I thought so. The next question is extremely important for a lot of parents. What should a parent do if visits are being missed or supervised unfairly? Which you and I know it happens. So yeah.
Well, that's interesting. I have a case right now where this is happening, and it's happening to such a degree that this is what I've told my client to do. I'm kind of new on the case, as a matter of fact. And this social worker, even though the judge has told all the attorneys off the record
Mm-hmm.
that she thinks that the social worker is making recommendations on the case because of a personal dislike of the parent.
The judge said that?
Yeah, to the attorneys off the record.
Oh my God.
And the social worker was sitting in the courtroom when the judge said this.
Mm-hmm.
Okay. And we're coming up on a trial. And I thought, okay, the social worker now is clued in and everything will be fine.
Mm-hmm.
Well, it's been about a week and everything is not fine, and everything is continuing and probably getting a little worse. And that's basically this social worker saying, F you to my client, F you, Davis. And, I don't care what the judge says. So this is the strategy that I have come up with.
Mm-hmm.
I wrote an email, very nice email, to the social worker's attorney, basically informing her of the problem, and asking for the makeup visits.
Mm-hmm.
She answered me several days later saying, "Oh, we're working on it. Don't worry, we're working on it." And in the meantime, my client's telling me, well, they're not working on it, and I'm missing more visits.
Wow.
So I gave her she's a very, she's a go-getter, this client. She likes to be involved in the case. So I gave her the standard assignment. Number 1, file a complaint with the DHHS, Department of Health and Human Services. They supervise all CPS throughout the country. They have a complaint form online. Number 2, file a complaint with the U.S. Department of Justice, Civil Rights Division. Number 3, file a complaint with the state of California, Department of Social Services. They supervise CPS within the state. Number 4, file a complaint with the county. I won't tell you the county, but with the county where that case is. Not that it will do any good, but at least they'll know that you're complaining. And those are the 4 things I told her to do. And the 5th thing that I told her to do was, we're going to file what's called a 388 and a motion for contempt against the social worker. Because, for the judge to say that the first time I show up on the case, it was off the record, but for the judge to opine that and then the social worker keep doing what she's doing, just shows me that this social worker doesn't care what the judge says or thinks about this case.
Do they ever?
So we have to take drastic measures.
Can relatives be denied for minor issues in their past?
Can they? I would say yes.
There's a new law. Remember that.
Can they? You said can they? Yes, but I think in most of the cases, the relatives can overcome those transgressions in the past. A lot of times I'll get a report that says, "Oh yeah, 25 years ago, Mr. Davis was convicted of drunk driving." That's 25 years ago. I was a different person, right? So you shouldn't hold that against me. And in fact, there is something in the process called a waiver, where you can apply for and get a waiver of that 25-year-old conviction, right? Now, it wasn't like I was convicted of DUI, last month, right? This happened 25 years ago, so I can apply for a waiver. So can they be denied? Yes, sometimes the social worker, especially if the social worker doesn't want to give you the child, they can be denied, but you can also ask for the waiver. And sometimes the social worker might not mention that to you. So you might want to mention to the social worker, oh, I know about that waiver process. Can I do that?
Hmm.
Next question, please.
Okay, so defense and strategy, that's the next segment. Um, how should a parent prepare to testify at any CPS hearing?
They should probably prepare with their attorney, and there are certain things that you should keep in mind. And I say this, and a lot of people chuckle, but this happens a lot. Don't yell at the judge. Don't curse the judge out.
And don't speak loud. Yeah.
Um, I just had this happen on a case a week or so ago. It doesn't make a good impression on the judge, and I've seen it many times where a parent who is winning has a certain emotional outburst, starts cursing, and of course ends up losing the case.
True.
This
Yeah,
happened.
but you know what? Maybe they've been in the system for so long that they're drained out. You know, social workers drain out parents. There's a mother that she was an attorney. She was on Stacy's show, and she killed herself from all the shit that they put her through. You know, there's a lot of emotional struggles that women go through, especially being without their babies, that men have no idea about. That emotional bond that they have with their kids. I understand it, but they have no remorse and they have no compassion and they have complete disregarded any parental rights that parents have, whether the social workers or the freaking judges. So
Do you think that's going to help them get their
I
children back?
just said it's not going to help them. I said the judges should take that into consideration and consider what the social workers put these parents through. There's a lot of stress that they put these parents through. That's the point I'm trying to make. Especially mothers, they have a bond with their kids from conception. I
Well, I
don't
can
like
tell you,
judges and I don't
it,
like social workers. So let's move on, okay? What is the highest, the biggest do's and don'ts for testifying on a case?
don't yell and curse out the judge.
Well, we know that now. How can a parent stay calm under cross-examination?
Practice.
Hmm. How do you explain that to practice to a parent? The social worker is telling them that they will never see their kid again.
You have to get someone and practice with them. If your attorney or someone from your attorney's office, um, get someone to question you under stress.
Mm.
That's the only way that you're going to become good at it, is through practice.
How does emotional honesty help or hurt your case?
That's actually a very good question. In most cases, it can help your case a lot.
How?
But you have to know how to be, they really call it emotional congruency in the trial advocacy world, in the world of Jerry Spence. It's called emotional congruency. In other words, your testimony has to be emotionally congruent. In other words, your tone, your body language, your physical expressions have to match what you're saying. because when your emotional congruency matches your testimony, you become more credible and more sincere about your testimony, and you become more credible to the judge.
I honestly think people should become narcissists when you have a CPS case. I'm act like a narcissist. The reason is because they're so cold on a, like, they're so disconnected from emotion. So it's like you can't have any feelings whatsoever when your children are stripped away from you. That's what I feel the system is, and that's what the system has demonstrated throughout the years, especially when it comes to juvenile dependency cases. Parents dealing with these cases, the emotional stress on parents, both men and women, I should say fathers and mothers. There's a lot of stress, and on the children too, when they medicate the children, et cetera, without your knowledge, or when they vaccinate your children without your knowledge. They strip you out of your rights from day one. Day one. So either learn how to be like a narcissist, emotionally detached from yourself to win your case. Because apparently, if you show emotions that you're crying in court because of your children, the judges see that as weakness. So you're dealing with a narcissistic system that has a tendency of sociopath. So you need to learn to disconnect your emotions, unfortunately.
I disagree with you, and I think you're focused more on being right than winning.
Has nothing to do with being right. It has a lot to do with facts. It has a lot to do with judges in the CPS courts when they tell parents, oh, their cries are fake. Why didn't you cry at the beginning of the case? There's a lot of parents I talk to throughout the day, maybe more than you talk to. I'm being honest with you because people have to make appointments with you. But with me, I talk to them ongoing every single day. And they all tell me the same freaking thing. If they show any feelings, they have mental illness. If they cry, they're mentally unstable. They recorded social workers telling them that. Some people illegally recorded court hearings. They're not supposed to. And I can hear the judge telling them that. Your cries are fake. I've heard court hearings where the judges are telling parents, oh, you're never going to see your kid again. That's from the first hearing. Okay, so come on, Davis, I talk to people all the time. And this has nothing to do with me wanting to be right. I wish I was not right. Okay, so let's just move on. Can a parent appeal if they lose custody at a 0.26 hearing?
Absolutely.
What's the difference between an appeal and a writ petition?
Well, there's different types of writ petitions. The writ that's most prevalent in a CPS case is the writ that you file after your family reunification services are terminated. An appeal is taken after the disposition hearing, after a 6-month review hearing, and after your rights are terminated. And then there's other types of writs that you can file at other stages of the CPS hearing when judges make rulings that, you don't like.
How fast how fast does a parent need to act if they want to file an appeal in California?
Within 60 days of the decision.
Can parents reopen their case after it's been closed?
Theoretically, yes, but the probability of them being successful is very low.
What do you consider successful? You said it's very low, but has there been a case where you handled, which I know you did, that was successful?
Well, yes, but That's not the norm, right? The stars have to align just the right way. Right? I think I've told people about this. I didn't work on this case. The lady called me and I told her that I couldn't help her. And I referred her to someone who did help her. And this was a lady whose rights had been terminated. Her parental rights had been terminated, I think, for 5 years. She petitioned the court to have her rights reinstated and got custody of I think, 1 or 2 children. And this actually happened in San Diego County. And I know the attorney that did it. I know the client. Because he first talked to me. And I didn't think it could be done. Or I thought it was such a low probability of success that I didn't think the woman should spend her money trying to do it. And, at that time, she was very desperate. And she goes, look, do you know anybody that might be able to help me? Just any person. And I said, well, yeah, I know somebody that might be able to help you. And I referred her to this person. And unbeknownst to me, he took the case. And then later on, he tells me in a conversation, hey, do you remember referring me a lady, blah, blah, blah? I go, yeah. He goes, she has a kid back and I'm getting her rights reinstated. I was shocked. But the stars have to align just the right way. So does that always happen? Can that always happen? No. But can it ever happen? Yes. I've seen it.
Can a parent, what's the most powerful comeback you've seen in a CPS case?
That one that I just told you about.
Okay.
5 years, rights terminated. You get your child back after 5 years, and your rights reinstated. That is the most. That's the most spectacular Hail Mary pass I've ever seen.
Amen. What's your advice for parents who feel hopeless right now? Which I know so many of them right now.
My advice is never give up. I don't know if you're a history buff, but during World War II, there was a leader of England, Winston Churchill, who made a very famous speech about never giving up the war, right? Never give up.
All right, let's address some questions here, and I really would like that. If you don't mind, is that okay?
Well, we can do it about 5 or 10 minutes. I have some meetings with.
I know you have a meeting today. I know that. Yeah, I know that with one of our clients.
And I can't miss that meeting, right?
No, you cannot miss that meeting. Believe me, I already spoke to him.
Okay.
Okay. Okay, I know you. Okay, so let's do this. How about if I copy all the questions myself, and then tomorrow, God willing, in the morning, we can have another show just to answer their questions.
That's fine.
Is that okay?
Mm-hmm.
If you want, tomorrow's Sunday. It's up to you. I have time tomorrow.
I do office hours 7 days a week, Miss G.
Okay, well, I'm not sure because I'm not your keeper, man. I don't know these things.
When you're sleeping, I'm doing the office hours.
While you're sleeping, I'm still working. Okay. I will go ahead and address all your questions, guys, because Davis does have a meeting. I had to set it up for him today in the office. So can you go now, Davis, and I'll just take their questions myself?
Sure. I'll go and I'll just leave it on. I'll just remove myself from the screen and you can do the questions. Okay.
Okay. Gotcha. All right, guys. If you guys want to have your question addressed, please write it down right now. What I'm going to do is I'm going to copy and paste it. And then for tomorrow, I am going to ask Davis the questions tomorrow morning, okay, on the show. So go ahead and do that. If you have any questions, I know Erica, you have questions. How can I address a concern about false positive with drug patches if the attorney or social worker won't allow me to switch to urine testing? That's a very good question, Erica. I am going to use that one for tomorrow's show. If you guys have any more questions, please address them now. Apparently, I can't copy and paste on this. So I'm going to have to take a screenshot of it myself so I can address the question tomorrow, Erica. Okay. I'm having an interest along, but yesterday at the facility, the staff thought they saw something on my person. Even I showed them there was nothing. They still canceled my test. I'm going to take, I don't know what you mean by person. So if you want to clarify that, Erica, I just found out that my social worker last day was yesterday and no one informed me. How will this affect me and what can I do to fix this? My question to you is, why would you care if your social worker's last day was yesterday? They change social workers on you guys all the time. That's because they confuse matters that way better, okay? You get a fake nice social worker that gives you false hope, pretends that she or he is on your side when they're technically not on your side at all. Then they send you the bitch from hell. That's just how the system works. Erica said, I've had a clean drug test all along, but yesterday at the facility, the staff thought they saw something on. Okay, yeah, I read that already. Erica, please clarify what you mean by person. Thus, they saw something on person. What do you mean by that? How can I address concern about false positive? Read that. Okay, where are we going here? I'm going to go to Dorothy. What if no reunification services are requested, nor any plan for reunification put in place when child is found safe with, I guess, parent? You meant to say it, but they still remove the custody of the child in North Carolina. Okay, so guys, this is what I'm going to do. I'm going to give you guys my email address. Okay, some of you know it, some of you don't know it. Excuse me. I mean, they thought they saw me concealing something in between my breast, they said. What the hell would you put between your breast? I mean, it was devised by evil, babe. It's not just men or women, it's evil. We're talking about spiritual warfare here. Erica said, my concern is because she's been the work of this whole time. My 6 months review hearing is in July and she was a bitch, okay? And I want to know if she was fired or if she just decided to leave, so I couldn't contact her. Let me explain something to you guys. Okay, some of you guys don't remember my shows or maybe never watched my previous shows, okay? Social workers who are assigned to you will never remain the same. They're always going to change. And that's all over the United States of America. The reason they do this is because they want to complicate the case. Now, remember something. If the social workers don't steal your innocent children from you innocent parents, they're not going to have money in their freaking pockets to buy their Mercedes-Benz. You have to understand they take incentives. They receive incentives for every child they steal from a good parent. The children who are really being abused, they keep them with the abusers. That's why I called CPS and the court system a demonic entity. They're literally stealing children for profit. That's it. And that's why there's a law that the judges take the recommendation of the social workers unless they have an attorney like Attorney Davis, God bless his soul, and God bless him always, who fights against the parent, against the CPS and against the judges using the law. Even if the parents uses the law in court, they're not acknowledged. They don't care what you say. That's why your court-appointed attorney is shit. Shit. Okay? That's my freaking opinion based on what I see day by day in the court system. Erica said, that's what I am saying. I showed her that there was nothing there and she still canceled my test. Then you need to have your attorney subpoena her behind for cross-examination. I'm sorry, so I can contest the report. Erica said, this is my third time dealing with CPS, and the first 2 times I've had the same worker through the whole time. This is very first time that I've had a different worker. Can we talk about child trafficking industry connection with the CPS? Would love to. My specialty. How can I get a detailed copy of my CPS case? You need to email your you can email your court-appointed attorney to request that, or you can go to the court with your ID and request that. Miss Christina said, I will get more money and a lot soon. I wish I had someone who liked what I did and care enough for my family. Address of grievance, though. Oh, honey, I love you, but I don't understand what you're saying. How do I ask a question? You can ask a question by writing it down. Can I get custody back if my daughter is now grown, but there is issues from when they separated her from me? You mean your child faced trauma because of what they put her through? You're gonna have to we're gonna have to address all these questions to Attorney Davis tomorrow's show. Okay, guys, look, I'm gonna put, if you guys have any more questions, you can write it, but I'm gonna put my email address down. At Vincent W. See. At vincentwdavis.com. Okay, so check this out. So this is my email address, okay, for all you guys out there. GAT@vincentwdavis.com. Email me your questions, okay? But please make sure it's clear. Make sure you go question 1, question 2, question 3 if you have more than one. Make sure it's clear, because Davis, I will ask him the questions. You guys are going to receive the answers tomorrow at 7 a.m. at 6:30 a.m., God willing. And that way you guys can hear the answers from the attorney himself, okay? You're so welcome, Christina. So please, 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 again, here's my email address. Email me all your questions. I don't care if you guys have 10 each. It doesn't matter. I would like to address that with Attorney Davis. But if you guys have a question for me right now, we can address it. If you guys want to text it, write your question. However, there was, hi, sweetheart. There was someone that wrote something about addressing sex trafficking through CPS. I'm going to say this. CPS are scumbags. All the social workers in CPS, I do not trust. Not a damn bit. They're the most corrupt entities on the face of the earth. They are worse than animals. You know, animals love each other. To be honest, an animal would protect its babies. You know, an animal actually have more care and love for human than those social workers. So they're scumbags. They're worse than scums. They're the they are the worst. I can't even call them human because they're not human. Okay. Anyways, what they do is that they put children in foster homes. Those foster homes are cartel or like drug trafficking or child trafficking homes. Okay. And the social worker claims that they did all their background checks and blah, 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 blah. But it's not true. It's not true. When the child runs away from home, from the foster home, they tell the foster parents not to report it to the police. They tell them that they only can report it to the social worker. So the foster parents are told not to report kids running away from home to the police. Why is that? The child is wandering the street, the child is being trafficked, the child is being introduced to drugs, etc., and they don't want them to look for the child. Let's just think about it. Just think about that. Erica said, yeah, I have PTSD from my first case with them. They actually adopted my son out. I am so sorry, Erica. I understand. It's hard. It's very, very, very hard. And after 12 months of trials and tribulation that they put parents through, like I said earlier on the show with Davis, just sometimes you have to act like a narcissist in order for you to win, meaning you have to be so detached from yourself. You have to be so detached from your emotions because that's the only way to win. You have to be bankrupt emotionally because if you show emotion in court because of the stress they're putting you through, the judge is going to evaluate you as crazy. Even though the judges and these damn social workers are the reason why parents lose their damn mind. Dorothy said, yes, they're stealing them for more than material things, but for spiritual reason, as well as not all are bad, but some surely are. Dorothy, with all due respect, sweetie, all of them are bad. But I'm glad we all have different opinions. Christina said, my sister didn't report I was homeless, ruined me. I just exposed that recently. In the show, you okay? I don't know what you mean by that, Christina. Erica said, I know the first one I went up to 24 months review, but I was still homeless and didn't get my housing in time, and it was too late, and I was on those fucking drug patches and they kept coming up dirty. Those drug patches, you guys really need to hire an attorney, especially an expert witness. Those drug patches are not accurate. Okay. The reason they want you on the drug patches is because they lace it with something. So that's why you need an expert witness, because these mother F's will do everything in their power to be right. See, they want to be right. They want to steal the children. They want to make profit. They want to make incentives. You guys need to really do your homework when it comes to CPS. CPS are horrible, horrible, horrible demonic entity. Erica said, that's sure not really. She's right, because my second CPS case, that lady was so fucking nice. It was unbelievable. I even requested if I can have her this time. Yep. I told you, they're always nice at the beginning. They want you to trust them. They want you to open up to them. They want you to be their best friend, but they have no friends. And even the word friends, like example, the word friends has an END at the end, right? End. The 3 letters at the end of the word friend is end. There is no friends. You have people that want to know about you to use it against you. You have people who are jealous of you that want to be your friend so they can hold you accountable to something that you shared with them. or they're using you to send information to someone else, or they want to steal your children from you or report you to the system so they can get some kind of money. Okay, so you have to understand something. Life teaches us a lot, and I am older than most of you out there, and I have lived life, and I have experienced the ups and downs and trauma and tribulation just like everyone else. But either life teaches you or you're going to continue repeating the same mistakes over and over again. You can't trust people. I surely don't. I used to. I used to love everyone to the point where I trust them so much. But you get hurt at the end. If you have someone that you care about, they either become your family, right? Family is loyalty, friends end your life, literally. Okay. There's one person that I can honestly say she's a friend, but family. She's actually family. Who she was a friend who became family is Stacy. She used to do the shows with me. She's family for life. I still, until today, she's my best ever. After my sister passed away, she became my sister. All right. But honestly, you have to be careful. These social workers are not your friend. Nobody in that system is your friend. Okay, they're never going to care about your children. They're never going to care about your grandchildren. They're never going to care about your niece and nephews. None of these people give a crap about you guys. All they want is the children, and that's the God honest truth. Okay. Grandparents out there, I wanted Davis to do a show with me about grandparents and relatives in general. 1 second. Sorry. I can get back with you after I see your email. Um, Sorry, guys. I had to shut the camera earlier because this nutcase is fighting with the cats. Um, Erica said, and the caregivers, either the foster parents, to be all friendly and buddy buddy with you, but they're, yep, they're cunning you pretty much. Oh, relatives out there, please. That's what I was saying earlier before you distracted me, Max. What they do is they separate the families. What they do is they trap the relatives, the grandparents, and what they give them false hope. Oh, you're going to keep the children. We just have to do a background check, et cetera, et cetera. David said earlier they're supposed to place the children with them, then do their background check on the caregivers, the family members. But there's also a new law, the SB 13, Nancy Skinner law, where it forgives, it doesn't hinder family members who have past conviction against them and they pose no current threats to the children, right? That law is in effect, and that law should be followed and honored, but oftentimes they don't even mention anything about that law. So you guys have to do your own damn research. And if you have any questions about that law, I'll be happy to email it to you. Betty said, Ms. G, do you have a phone number so I can call you? Yes, I do. What I need you to do is when you guys email me, leave in your cell number and I will call you from a 310 number. Okay. I usually use my cell, but I will call you from that number. My direct work number is 626-631-8901, or you can call the 888 number that you see on the screen right here. Right here, if you guys can see, right here, where my finger is, and then that number, and then ask for me. Okay, the receptionists usually answer the phone. Christina said, small phone, no glasses. I was strangled, hurt my eyes. I can relate to that, my dear. I can barely see with my eyeglasses. Thank you so much, baby girl. Betty said, I have been fighting for my niece for 2 years, and the judge granted her to be with me, and I have not received her yet. Interesting. I want you to write a question, Betty. My email address, let me show it to you guys again. Here's the email address. Please, Betty, write that question down, my love. Write it down. Write whatever question you want to be addressed tomorrow. Okay? That's very important. Whatever question you need, Attorney Davis, to answer for tomorrow's show, please email it to me, and I'll be happy to address all you guys' questions. What's a drug patch? A drug patch is what they put on your arm, kind of like what if you want to quit smoking, you have like a patch or a gum you chew. Well, drug patch is kind of similar. And what it does, it just shows them if you're still doing drugs or what have you. I don't know, it's something like that, but I'm not the one to ask that really. I don't know too much about it, but I do know from previous clients of ours where they said they've never done drugs and the drug patch came back positive, right? Right. So what you need to do when there is something like that, you need to get an expert witness on your case or ask an expert witness about the drug patch, because for sure they do something with the drug patch where they make it look like you're still doing drugs and you're not. You're really not. The reason I know you're not, because a lot of our clients do their own drug testing, or we send them to do their own, we send them to drug test themselves or do hair follicle tests, and it shows that they've never done drugs. Okay, especially the hair follicle test. It can go up back to 8 months, a year. Okay, so what I'm saying is when that happens and then the patch says you're positive, what does that mean? It means they're doing something to these damn patches, because you have to go to their own facilities to get these drug patches on, right? Thank you, Christina. Okay, I want you guys to again write your questions down. I'm gonna have to end up the show now. Hold on. Where's my email address? Okay, so this is the email address you guys need to send your questions to. Okay, God bless you all, and I'll see you guys tomorrow. Me and Attorney Davis will see you guys tomorrow at 6:30 a.m.
I'd like to thank Mr. Davis from the bottom of my heart. I'm going to cry. Without Mr. Davis, I wouldn't be back with my baby. I wouldn't be able to put my baby down at night. Without Mr. Davis, I wouldn't have been able to fight CPS. I wouldn't have known what to do and where to go. And if you're in the situation and if you don't know who to turn to or where to go, you need to call Mr. Davis. And you will definitely get the help that you need. Thank you, Mr. Davis.